hai, and today I will be discussing the topic Keshavanand Bharati judgment. This judgment came on 24th April 1973. This judgment proved that Indian constitution is supreme. What is constitution? See, constitution is a legal document. For some people, their sacred book is Gita. For some, it's Quran. But because India is a secular country where there is a rule of law, so our sacred document is Constitution. Constitution is supreme in our country. Supreme means ki nobody is above the Constitution, whether it's president, prime minister, or anybody. Constitution is supreme. This Constitution was under many threat, and this threat came to an end on this date, 24th April 1973. I will be telling you about the judgment, but before going further, I will be telling you the background of the judgment. So, Indian Constitution has 25 parts total. Today we will be discussing mainly 3 parts, Part 3, Part 4 and Part 20. Part 3 is related to fundamental rights. Fundamental rights, we all know, it's basic rights given by the Constitution to the citizen for their all-round development. Although it's not absolute, the government can put a reasonable restriction on it. Part 4 deals with DPSP. DPSP is basically the instrument of instruction given by the Constitution to our leaders for the welfare of the citizens. Part 20 deals with the Constitution Amendment. What is Constitution Amendment? See, as the time changes, the need of the society also changes. And with this need, there is need to change the Constitution also. So, the process to change the Constitution is Constitution Amendment, Article 368. We will be mainly discussing these 3 parts. See, when Constitution enacted and enforced at that point of time, there was dispute between these 2 parts, that is FR, Fundamental Rights, and DPSP. What was the dispute? Let us understand it through an example. You might have heard about land reform. What is land reform? See, there are many things under this term, land reform. But at that point of time, in 1947, I will be mainly discussing 2 major points, that is abolition of zamindari system and land ceiling. Abolition of Zamindari and Land Ceiling Act. Zamindari system, you know, the government said at that point of time that there should be no zamindars between the farmers and government, and there should be direct link between the government and farmers. In the same way, the government came up with the idea of land ceiling, and government said ki land ceiling ki there should be a limit on the land purchased by the people. Let me take you through an example. See, let's take an example ki government said ki there should be maximum 25 acres of land with anybody, and if any person having more than 25 acres of land, then government will be taking that land away and redistributing that land to the landless labor. Okay? So the government said ki we will be implementing Article 39B and C and giving preference. The government was giving preference to DPSP over the fundamental rights. Okay? Acha. So, petition, the people went to the Supreme Court and said ki government is giving preference to the DPSP, Article 39B and C. What is Article 39B and C? Article 39B and C is related to the distribution of the wealth material or material and the prevention of concentration of the wealth. Okay. So the government said कि yes, we will be giving preference to the DPSP over the fundamental rights, and people went to the Supreme Court, said कि government is snatching our right. Article 19(1)(f) and Article 31 related to the right to property. Okay. So, Supreme Court said कि yes, the government cannot give preference to the DPSP over fundamental rights. In the same way, there was one more judgment. You might have heard about the Champakam Dorai Rajan case. Madras government came up with an idea called reservation in education. And the government said कि we are giving preference to the DPSP over fundamental right, and we are giving reservation, providing reservation to the backward strata of the society. So the government was giving preference to Article 46 over Article 14 and 15. What is Article 46? Article 46 deals with the promotion of educational and economic interest of the SC, STs and weaker section of the society. Article 14 is right to equality, and Article 15 deals with that state shall not discriminate with respect to race, caste, sex, place of birth, and these should be taken into consideration. And that is why the petition flooded into the Supreme Court, and the petitioner said कि government cannot give preference to the DPSP over the fundamental rights, and hence Supreme Court under Article 13 and 32 said कि we are the guarantor of the fundamental rights, and we should, and as per Constitution, fundamental rights should be given preference over DPSP. Here Article 13 deals with that any law which is in abrogation of the fundamental rights should be declared null and void. Article 32 deals with the constitutional remedy. So in this case, again Supreme Court said कि yes, fundamental rights should be given preference at any cost because Constitution says so. So, but one more thing, the court said one more thing in this judgment, and court said कि but Parliament can amend the Constitution in order to implement DPSP. And this judgment gave the boost to the first Constitution amendment. Okay. So what is first Constitution amendment? How it came into effect? What was the further cases which led to the Keshavanand Bharati case? These all things we will be dealing in the next class. Hope you like it. Thank you so much.